what are the requirements to be named as the personal representative in the state of Florida? So the personal representative, also known as an executor, but in Florida we use the term personal representative. That's the person in charge of the probate, okay? So that's the person who's going to be signing the documents, going to court if necessary, hiring the probate attorney, bringing a wrongful death case if the person who died passed away as a result of an injury or something like that. So the personal representative is really what we would say the person in charge of administering the estate, dealing with creditors, liquidating assets, all that sort of stuff. So who gets to be that person? Well, in Florida, the laws are pretty clear about this. If there is a valid last will and testament, the person named in that will is going to be the personal representative, right? If someone did a last will and testament and they say who they want their personal representative to be, that person is going to be the personal representative. If there is no will, then there's a hierarchy of who gets to be the personal representative. So first it's going to be the surviving spouse, if there is one. So if there's, husband died and wife's alive, she has priority to be the personal representative. If there is no spouse, then it's going to be consent from a majority of the heirs. So if there's 3 kids and 2 of them choose one person, then that person has majority. He or she gets to be the personal representative. And then number 3, if there's no consent, it's going to be next of kin, and ultimately the court could decide who that person is going to be. So it's relatively black and white as far as who gets to be the personal representative. However, there's also a couple things that you cannot be to be the personal representative. First of all, if you're a convicted felon, you can't be the personal representative, no way around that. And number 2, if you're not a Florida resident and you're not related to the person, you cannot be the personal representative. So we see this sometimes where, someone does a will, they name their best friend as the personal representative, but the friend is a resident and lives in New York. Well, they wouldn't qualify, even though they're named as the personal representative. Since they're not a Florida resident and they're not related to the person, they would be disqualified. So you could be a non-resident, you could live in New York, but so long as you're related to the person, then you can be the PR. So those are the basic requirements: the person named in the will, or if not, it's going to be a surviving spouse, consent from the majority of the heirs or next of kin, and the court might end up deciding that. And you can't be a convicted felon, and you cannot be a non-resident and non-family member to be the PR. So if someone has passed away and you've been named as PR in the will, or you think you're going to be, try to get it started as soon as possible, and essentially, because there could end up being a fight over who gets to be the PR.